Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be Landlord's Survival Guide, expert answers to your toughest questions. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the song was Your Song, and that was, of course, sung by Elton John. The lyrics were actually written by Bernie Taupin, but the music, of course, composed by Elton. It was a straightforward love song which Bernie wrote in 10 minutes while having breakfast at Elton John's mother's house. It was actually released in 1971, became a monster hit, and launched Elton's career. Okay, let's talk about the show format. We start with an opening topic, and then after the opening topic, those parties that are in the Zoom meeting will be able to ask questions if they electronically raise your hand. I take the questions in the order of which people raise their hand, so please electronically raise your hand if you're in the Zoom meeting, if you want me to call upon you. If you're watching this on YouTube, thank you very much. And I would appreciate it if you could hit that like button and subscribe to the channel, because it really does help me. Also, if you're in YouTube and you have a question, just put it in the comments and I'll be sure to get to that. And also, if you have a suggestion for future opening topics, please let me know. All right, what's the opening topic today? It is Landlord's Survival Guide, expert answers to your toughest questions. These are the essential and critical questions that landlords ask. Now, I'm sure a lot of you do know that I write a column for the Apartment Owners Association magazine. It's the legal questions and answer column. I do that once a month. I've been doing it now for 40 years. So if you ever get the magazine, check out that section. But during the time that I've written that, we actually take members' questions and answer them. And sometimes these questions are so significant that I get asked many, many times, and they're crucial questions for landlords to understand the answers to. So right now, what I'm going to do is I'm going to read some of those crucial questions, those critical questions that I do get asked and which landlords really need to know the correct answer to. So I'm actually just going to read these, and these are from actual members from the Apartment Owners Association. Here's the first one. I recently was served by the city of Alhambra a notice of violation that there was a plumbing issue in one of my units. My tenant never informed me of a problem. I served a proper 24-hour notice to access the premises, and when I showed up, the tenant refused to allow me and my plumber to access the unit. I am sure that this tenant is trying to set me up with a lawsuit. Any suggestions? Well, that's very common that tenants will not tell a landlord of a problem and then go running to the city to complain about that. It's just what tenants appear to do. In this situation, what I would do is I would serve a new notice to enter the dwelling, stating the exact time and date that you're going to be going in and what the reason is. Of course, make sure that when you're going to access the units during normal business hours, Monday through Friday, 9 to 5. But I would also write something else on that notice. Just fill it in somewhere. And by the way, I have that access notice on my website at evict123.com, and that's in the free form section. But fill in another phrase that says, I came there on last Tuesday and you refused to let me in even though I gave you proper notice. If you refuse to let me in this time, be aware that I will be bringing forth an eviction, because that is a ground to evict the tenant when a landlord has properly asked for access to a unit and the tenant has refused. So put that right on the notice. Now, when you arrive at this second time, have your smartphone out and ready, because if he won't let you in, what you should do is video it, record it, and this way you'll be able to have perfect proof that the tenant didn't let you in terms of an eviction. With regard to the violation, I would contact the building inspector who wrote that, explain what the problem is, and explain that now you're going forward with an eviction. Okay, let's move on. Number 2. My tenant is complaining that there's mold in her unit. I inspected the unit and did not see any evidence of mold. However, I did smell a foul odor which I could not trace to the source. I told her to keep her windows open and to use air freshener. She was not happy with my response. What would you recommend? Well, I recommend not getting sued. So, on that basis, if you can't determine what the source of that foul odor is, you need to get it tested immediately for mold and therefore get a certified mold company to come over who will check for any leaks and also would do air samples to see if there's anything dangerous in the air. Many times you have leaks that are behind the wall. The pipes run behind the wall. And if there's a leak behind the wall, you're not going to see any evidence of mold, but it is going to be building up and it will create a hazardous air situation. So again, in that situation, if there's any suspicion that there could be mold, get it tested. I understand that it's not inexpensive to have it tested, but I can tell you what is expensive, and that is when you get hit with a lawsuit, which in many cases your insurance companies are not even going to handle. So spend the money, get it tested, figure out what the source of that odor is. Okay, number 3, there was a leak in one of my apartments when a pipe burst. The tenant's unit was flooded and some of his personal property was ruined. He claims to have lost an iPad and a gaming computer worth over $12,000. He is demanding that I pay for it. What are my obligations? Well, in law, generally, a landlord can only be held liable based on 2 legal theories. One is negligence, and the other one is based on a contractual basis. So what's negligence? Well, you should know what negligence is. You're driving in your car, you're looking down at your cell phone. I think Jim Polina is doing that right now. And you hit the car in front of you. Well, if that's the case, clearly you were negligent. So the issue is the theory of negligence applicable in this situation when a pipe bursts in your unit and a tenant's property is damaged? And the answer to that is no. How would you know when a pipe is going to burst? You can't sit there and check the strength of all these pipes and realize that one is going to burst. So therefore, on a negligence theory, you're not going to be held liable. Now, could you be held liable on a contractual theory? Well, that would mean that you'd have to have a rental agreement that says, yeah, Mr. Tenant, if anything happens to your personal property, I'm going to take care of that. Well, we know you don't have that in your rental agreement. So on that basis, under a legal theory of negligence or on a contractual theory, you cannot be held liable for the items that the tenant lost. But you should go one step further. In your rental agreement, you should have a paragraph that talks about a requirement for the tenant to carry renter's insurance. This renter's insurance would cover any damage to his personal property, and it would also cover any expenses if he has to temporarily relocate. Let's pretend that the apartment is flooded and now he has to leave. And that paragraph should be contained in your rental agreement. I know it's in my rental agreement, so check your rental agreement. Or again, you can get my rental agreement. It's free. It's online at evict123.com. And use that for any new tenant coming in. If you have existing tenants, you can use what we call a change of terms of tenancy. And you can serve that on your tenant as long as the tenant is on a month-to-month tenancy. And of course, that is also contained on my website. So with regard to the being held liable, you shouldn't be held liable under that theory. Okay, number 3, I have a new tenant who moved in with a dog. On his application, he stated that he did not have any pets or animals. When I saw the dog, I immediately objected. He presented me with an emotional support letter from a doctor. Since he lied on his application, I want to immediately bring forth an eviction. Do I have the right to do this? You might have the right to do this, but I'll tell you something. You're going to get sued under the California or Federal Disabilities Act. Once the tenant has shown you a proper letter from a medical professional, then you have to allow the dog there. I know that the tenant lied on his application, but that's not going to trump the fact that he has the right to have an emotional support dog. He does have to have a letter that qualifies under California law, which means that it must be from a medical professional. It must have the doctor's license and must be licensed in California. It must state that this tenant has a disability and needs the services of a comfort animal. And also, it has to state that he treated with this medical professional at least 30 days prior to issuing this letter. If your tenant presents you with a letter which has all those elements, you better accept that dog or you're going to get sued. We once had a letter, believe it or not, from a chiropractor who's talking about a disability for the tenant. I don't really get it, but of course I advised my client that they had to allow the animal to occupy the property. Okay, number 4, how do I protect myself from being charged with discrimination when I lease my units? I believe that I have people calling me that are just attempting to trap me. Well, that certainly is the case. Let me define what illegal discrimination is. It's defined as the issues dealing with race, color, ancestry, national origin, religion, sex, sexual orientation, disability. Also, California includes discrimination based on marital status, medical condition, including cancer and genetic characteristics, also military, and of course, Section 8 applicants. Now, legal discrimination, which is also known as free choice, is based on credit worthiness and certain characteristics of your tenant's history. For example, nuisance behavior, damage to the property, past evictions, or being involved in numerous lawsuits. These would all be considered legal discrimination where you could reject an applicant based on that. So we talked about illegal discrimination, but we also have to be conscious of the fact of legal discrimination. Now, the best way that you can avoid any kind of a discrimination case, and it's also now the law, is to have what they call your renting leasing requirements. And I'm going to share my screen now, and I'm going to show you what that looks like. That is a form that's on my website, and it is called rental leasing requirements. Technically, you cannot take, based on the new law, an application fee from a tenant unless you first gave him your leasing requirements. And I would have him sign a copy of that so that you can prove that you gave it to him, or you can just photocopy it onto the back of your application. But on this, it talks about the fact of that you're requiring, for example, an income level of at least 3 times the amount of rent. It also talks about the fact that he has to have a satisfactory credit score, which we're saying in this example, a 700 credit score, that there can be no negative credit factors such as bankruptcies or collections, that he must have never been a party to an eviction case, and that he also needs to prove to you 6 current payments to his landlord. So in other words, the last 6 months worth of payments to his landlord. So by giving him this criteria, number 1, you have the right to charge an application fee, and also you have the right to be certain that you're not going to be charged with discrimination, because if you reject an applicant based on that they didn't meet this criteria, it's going to be hard pressed for the tenant to declare that you were doing illegal discrimination when he didn't meet your criteria, which you handed to him before. Again, you cannot charge an application fee unless you have given him this application. So this is on my website. Please use it, the renting leasing requirements. I also have an application on my website. Okay, let's move on to question 5. Am I required to lease to a Section 8 tenant? I have heard horror stories from other landlords regarding rent increases, inspections, and damage to the property. Well, I already told you that under California law, that's considered illegal discrimination. You have to allow, at least take an application from a Section 8 tenant. You can't just summarily reject them. And there are these call screeners that are calling that are asking over the phone, hey, do you take Section 8 tenants? And if you say no, you are going to get sued. These are call screeners that are looking to pounce upon you and to sue you. So make sure that you do give an application to that Section 8 tenant and go through that application. Now, in the past, I always used to tell my client, don't worry, you'll be able to reject the applicant because you're going to run a credit check. And by running that credit check, he's invariably going to have bad credit and you'll be able to reject him. But unfortunately, in January of 2024, they changed the law and they talk about that you cannot reject a Section 8 applicant based on credit. You can only do it on the ability to pay. So what is the ability to pay? Well, we all know that Section 8 is a subsidy, so they'll pay the majority of the rent, and the participant, your tenant, will pay a small portion. Well, if the tenant can prove that he has the ability to pay the rent for that small portion, then you have to allow him, even if he has bad credit. This is an insane law that was instituted by our California legislature, but it is a law that we have to follow. However, that doesn't prevent you from rejecting an applicant based on legal discrimination, that is nuisance behavior, proof that he's damaged the property, past evictions, being involved in numerous lawsuits. However, there's one other way that you can legally reject the tenant, and I've talked about this before, and that is when you have, from now on, when you lease property, do it on a month-to-month basis. Section 8 will not accept tenants unless it's a minimum of 1 year. And I've discussed before that there are other reasons why you should be renting on a month-to-month basis, but this is also an additional reason. So that's got to be across the board, no matter who's coming to your unit. You are now only going to advertise month to month. By doing that, then even though you desperately want this Section 8 tenant, yeah, right, Section 8 will not approve. Let's move on. I recently lost a small claims court against a former tenant that was brought for failure to return a security deposit. The judge found that I could not deduct late charges that the tenant had accrued over the course of his tenancy. What are the rules relating to a security deposit? Well, first of all, from a security deposit, and I want to go and share my form because I do have this form on my website, so let's do that. From a security deposit, you are allowed to deduct reasonable wear and tear. You are allowed to, for unreasonable wear and tear. You are allowed to deduct for for general cleaning. And also you're allowed to deduct for any rent owed. Now, the reason why the question member lost that case is that late charges are not considered rent. So if it's not considered rent, then you're not allowed to deduct it from the security deposit. It would have allowed you to sue the tenant in small claims court, but you're not allowed to deduct it from the security deposit. The only difference would be if the rental agreement stated that, stated that that all monetary obligations are considered rent. If they're considered rent, then you can deduct it. So this is the security deposit form. It is on my website, and you can fill it out. It's fillable, and then mail it to the tenant. You have 21 days from when the tenant vacated the unit. Now, I always get the question is, what is unusual wear and tear? I'm going to stop sharing my screen here. Unusual wear and tear is, or reasonable wear and tear is refers to expected deterioration of property due to normal use and aging, not as a result of negligence or misuse. It's the natural depreciation that occurs over time in a rental unit. So if a tenant's been there for 20 years, obviously there's going to be natural deterioration. But if you see gaping holes in the wall, that would be considered unusual. Or a broken shower door where the glass was broken. These would all be considered unusual wear and tear, and you are allowed to deduct it. Now, under the new law, you have to take pictures of the unit before you lease it. You also have to take pictures of the unit after the tenant immediately vacates. And also you have to take pictures of the unit once the unit is restored. Those before and after pictures have to be included under the new law with your security deposit itemization that you mail to your tenant's last known address within 21 days from when the tenant moved. And also under the law, once you have served your tenant a proper notice to vacate, or your tenant has served you a proper notice to vacate, then you have to offer the tenant within 2 weeks the right to a pre-move out inspection. That's where you're going to go and meet the tenant inside his unit, and you're going to point to those items that you're going to be deducting from the security deposit. It's not a complete list because you get to redo it once the tenant vacated. And then this will give the tenant the right to fix those items so that you will not be deducting it from his security deposit. And by the way, under the law now, under the crazy law now, when you are leasing out a unit, the maximum security deposit is only 1 month's rent. It doesn't matter whether the unit is furnished or not, it's 1 month's rent. The only exception to that would be if you own two properties with a maximum of 4 units. If you own two properties with a maximum of 4 units, then you would be able to charge a security deposit equal to 2 months' rent. Now, if you do own, let's say, two 4-unit buildings, so you wouldn't qualify, what you could do to get around this law is to put one in an LLC, a limited liability company. And by doing that, then you'll only have one owner for that 4-unit building. So for both units, both buildings, you'd be able to charge a double security deposit. And then the last question I'm going to ask is, my tenant vacated the unit, leaving some of his personal property. What are the rules regarding disposing of these items? Well, there is a form that you need to fill out, and I'm going to share my screen again and again. This is on my website, and it deals with the notice of right to reclaim abandoned personal property. You need to fill out this form on my website and mail it to the tenant's last known address, where you list the items, the personal property that was left behind. Now, there's 2 boxes to check. If the property is worth less than $700, then you need to hold a public auction. Excuse me, if the items are worth less than $700, then you can toss it away after the 18 days from when you mail this notice to his last known address. By the way, the last known address, if you don't know where he moved to, would be your property, that apartment. Now, if it's worth $700 or more, then you have to hold a public auction. And I have a referral here, and that is Allstate Auctions. And their phone number is on the bottom there, 818-994-8243. So after you filled out that form and you waited 18 days, if the stuff is worth more than $700 or more, then you do have to hold a public auction. Feel free to use anybody, but we have been recommending to our clients these people. And that, ladies and gentlemen, concludes our topic of the day, Landlord Survival Guide, expert answers to your toughest questions. And now we're going to open it up to questions and answers by our people in the Zoom meeting regarding that issue. Remember that this telecast is for informational purposes only and is not a substitute for legal advice. If you do want to talk to me and you're in the meeting room, please electronically raise your hand. And remember that this forum is for general questions only. If you do have a specific case with my firm, we only will talk about general questions. Please call us at the office. If you are talking to me, please leave your camera on because it makes it more enjoyable for everybody watching. And again, if you are watching on YouTube, please hit that like button, subscribe to the channel. And if you do got questions, well, you can ask it. Just leave it in the comments, or maybe you want to suggest a topic for a future show. And with that, we're going to go to our old-time regular, Jim Polina. How are you, sir?
Hey, happy Saturday, Dennis. My favorite time of every Saturday.
Thank
I
you.
have a kind of question stories to ask you or tell you. First, is it true, as reported in the news, that LA City is going to pay the rent for illegal aliens?
I haven't heard that. I heard they were voting on it on Friday, that they were going to do some sort of an eviction moratorium if the tenant could prove that he was some sort of a victim of ICE, really. But I haven't heard whether they passed that or not. I would hope that they come to their senses and just leave landlords alone, but it seems like they have to keep trying to hurt us every step that they can.
That's an eyebrow raiser.
Yep.
Okay, number two. Now, this is wild. I got this firsthand from a lady who works as a firefighter in Oakland. I said, is it true that there are like thousands and thousands of vacant units in the city of Oakland? And she said her comment immediately was, yeah, those landlords are making money hand over fist. And then my comment was, how can they make money on a vacant unit? And she said, because Section 8 people move in and then eventually they leave for whatever reason, become homeless, get hospitalized, but the rent keeps coming in. There's thousands of these things. What do you think about that? Is that
I haven't
um,
heard that, and I don't know why a Section 8 tenant would leave and not tell Section 8, because where is that Section 8 tenant going to go? He's going to need to get another voucher. So by getting another voucher, they're going to cut off the income stream to his current landlord. So that story doesn't make any sense. I could see these landlords leaving it vacant because they want to do Airbnb. I'm not sure what the laws are in Oakland with regard to renting out your property under Airbnb. I know that it's almost impossible to legally do it in the city of Los Angeles, but I don't think that story is accurate, Jim.
okay? Thanks for your input.
All right, we are moving on to Harold. How are you today?
Um, Dennis, good stuff, man. Really good stuff. Okay, here's my question. If I have a tenant, like a new agreement, and it's actually a roommate scenario, and I wanted to make the language more limiting, like this arrangement is for a single room only, is it too strict to say that tenant has access to one bathroom and that's it in the whole house, even though sometimes he might use a kitchen or something? Is it too
I
limited?
I think you can make any terms of the contract that you want. I don't think it's illegal to do that. So you're going to and it would be reasonable for him to be given the exclusive use of one bathroom. So I don't have a problem with that. But you don't want to allow him to use your kitchen.
I just want control of it in case he's a total slob and messes it up and doesn't clean it.
So you're going to put it in the rental agreement that you can't use the kitchen, but you're not going to enforce it unless he becomes a slob?
I don't know how to, that's why you're here, man, to make it sane.
I don't know about that. We know that if you don't like a tenant and he's on a month-to-month tenancy and you live in the same house, you certainly have the right to terminate that tenants, even in this Gestapo land of Los Angeles. Anyway, thank you very much. We are moving on to, it says here, iPhone guest. I'm going to ask you to unmute yourself.
Hello, Dennis. Good afternoon.
Hello.
Two quick questions, if I may. First one might be a little out of the ordinary. I inherited a lease contract for a washer and dryer machine from a company upon purchasing an apartment building. Um, as soon as the contract rolled over from set term to month, I called to or I emailed to cancel. They agreed to remove the machines, but it's been months and the machines still sit at the property. Wondering what would be the best next course of action. Am I allowed to just remove the machines myself?
First of all, that's considered a lease. And second of all, why don't we tell which laundry company is refusing to honor their own agreement? What's the name of the company?
CSC.
Is that CoinMac? Is that the one?
I'm not sure. My bill just says CSC.
CSC. Not familiar with that one. I've heard of others like Dotson and All Valley Washer. Uh, that's actually an eviction case, and we have evicted um, laundry companies from your laundry room because they set this up as a lease. And while we're on the subject, be very careful. First of all, if you buy a building with a laundry contract in place, you have to honor that contract. That's what you bought, that's what you got. But these contracts are insidious because what they do is they have an automatic renewal provision that after the first 10 years, it automatically renews after the second 10 years. They go on for life. And then there'll be a phrase in that in order to cancel the agreement, you have to do a 60-day notice prior to the expiration of the lease. You got to mail it certified mail, return receipt. So don't get involved in any of these laundry leases. And really, before you enter into one, make sure that you look at the terms of those contracts, that they don't have any automatic renewal provisions in them. But the smart money, and I know that's what I do in my buildings, is I put my own machines in. You can have them, they're either coin operated or you can get them now where you can actually use a credit card on them. And this is really just a smart way to do business. So try to avoid these. But if you buy a building and that laundry contract is in place, these people are all bad, in my opinion. And I would not deal with these companies at all. Just put your own machine in. Thank you very much. And let's see. We're moving on to Kay. Kay Tolentino, how are you?
Hi, Dennis. How are you?
I am fine,
Uh,
thank you.
Great. The last time I saw you, you were helping us in Pasadena with our Measure H that came down to Pike a few years ago. So I think that was the most stringent city rent control that we've seen ever since City of LA. So thank you for coming and breaking it down for all of us. I have two questions. I just want to kind of preface that the situation falls under a non-RSO. So it's a single family exempt from RSO in the city of LA, where the owner is just an individual, and there is a tenant, and then there's an illegal subtenant. There is just cause. Everything's registered with the city, and they have stopped paying. And so there's the just cause portion of it, but they are claiming habitability. So my question is two things. How does habitability play in evictions? And if it gets to the point of a trial, are you finding that the judge uses the actual law, whether it be AB 1482 or the JCO ordinance, when deciding on a case like this?
Well, it really, you're not really subject to, for a single family residence, you're not subject to AB 1482, the Tenant Protection Act, because you're under now the Just Cause Ordinance for the city of Los Angeles. Now, if you're evicting a tenant based on an unauthorized occupant, if they raise habitability, that doesn't relate. So we would be filing something called a motion in limine to strike that, because a habitability issue only deals when we would be seeking rent for that unit. So if we were suing for rent, the tenant didn't pay the rent, then habitability would be a proper defense. But it's not a proper defense. For example, if the guy breaks the unit, just takes a pickaxe to the unit, or in your situation, violates the terms of the contract by having an additional person there. I did want to talk about, and you can stay on for your follow-up question, but there was on the last week's show, I did take a look at it, and this dealt with being able to raise rent in the city of Los Angeles due to the emergency order by the governor, which I said was extended until January of 2026, and that was wrong. They have extended it until August 1st. So right now, if you wanted to do a whopping rent increase for an existing tenant after August 1st, you can serve that 90-day notice, because I presume it's going to be more than 10%. And that would be perfectly permissible. There are no rent limitations, regardless of who owns the property, regardless of JCO or under AB 1482, you can raise it. So I did want to correct last week's show that The governor's emergency order is over as of August 1st, 2025, not as of January. Did you have a follow-up question? Janice? No? Okay. We'll move on then to Janice. I'm going to ask you to unmute yourself.
Hi, Dennis. How are you?
I'm good. How's the weather in New York, young lady?
Hot and humid.
It's
And
hot
full of,
here, but it's dry, as we know.
yeah, I know. I miss the dry weather. And full of political drama. Which just seems like it's part of the weather now. But anyway, the question I wanted to ask you is about the owner move-in exemption. If an owner decides to move in for a continuous period of a year, can the owner not have shared the house with someone? Does it have to be taken out of the rental market?
I think you can have another person move in. It's just the way the law works for AB 1482 is that you just have to use that as your personal residence. I don't think that's true in the city of Los Angeles. In the city of Los Angeles, you can't rent it out. So even if you had somebody coming in, you're not allowed to do that. They don't have that restriction under AB 1482.
I see. Thanks a lot.
Okay, good question as always. We are moving on to Arana. I think I pronounced it right. Are you there?
Yes, can you hear me?
Perfectly.
Oh, great. Thank you, Dennis. So the situation is tenant divorced. So one is going to move out and one wants to stay. And can I just terminate the lease because initially I leased out to them based on their combined income. Now one is going to stay. I don't think that person able to afford the rent. And
What
so
you don't
what are my
understand,
options?
yeah, what you don't understand is what makes you think that the person departing tenant isn't still responsible. He signed the rental agreement. He's still on the rental agreement. So I don't care that he's not living there. A partnership rented the unit, and the partnership is responsible for that unit until the partnership totally vacates the unit.
Okay, what if the one is leaving wants to be removed from the lease?
Well, that's all well and good, but you're going to say no because the other person
Okay.
doesn't have proper credit. If the person had proper credit, then you might want to allow that, but you don't have to allow that. You guys both signed the lease. When you guys both leave, then the lease is terminated.
Okay, so I don't have to agree to it.
That is
Let
correct.
one person remove themselves. Okay, great. Thank you, Dennis.
Good question. We've been getting some great questions these days. And now we're going to move on to Margaret O'Brien. How are you?
Thank you. And your responses in the AOA magazine are the first things I always read. Very informative. But
Well,
now,
I hope Jeff Fowler, who's the president of the Apartment Owners Association, is listening.
yeah, I'll tell him when I see him. I have a non-rent controlled duplex in Manhattan Beach, and somebody is moving out. Do I have to take pictures? I don't expect damage, but do I have to take pictures and do I have to pay interest on the security? Non-rent
Well, first
control.
of all, this is a statewide law dealing with the pictures. So the answer is if you're intending to deduct anything from the security deposit in terms of damage, then you do have to take pictures immediately after the tenant vacated, and then you have to take pictures after the premises are restored, and those pictures have to go with the security deposit itemization form.
Yeah. And do I have to pay interest on the security deposit in non-rent controlled in a duplex?
No, that city does not require
Okay.
any interest on security
And
deposits.
then my last question is, what do you think of Airbnb?
I mean, I think it's great if the municipality allows you. So definitely check with the specific municipality. I know Los Angeles has rules that the owner has to live in the unit and then can only rent it out, I think, for maybe 1/3 of the time. And the same thing is true for tenants that if it's a tenant is doing it, you also have to have a license in the city of Los Angeles for home sharing, as they call it. So there's all sorts of rules.
Yeah.
But if your municipality doesn't have any restrictions, then I think it's really good. It's a wonderful income stream that you're going to make much more money, especially where your property is, which is in a beach community. That's very attractive. People always want to be by the beach.
Okay, thank you very much.
Thank you. And let's see, we're going to move on to Laura Corral. How are you?
I'm doing great. Thank you for these informative sessions. My question is in regards to these current ICE raids. Let's say that one of your tenants was taken in by ICE, and a family member is trying to enter the unit to take stuff out. How do you handle and navigate these situations? Because it's not likely that they're going to come back. So can we rent it out? Do I have to hold the apartment? What are the legalities to navigating this situation?
Well, I don't think it's an abandonment. Are you sure that the tenant's definitely getting deported?
I'm not sure, but there have been family members saying that they need to enter the apartment because the person was detained by ICE. It's been over 8 days. I haven't seen the tenant on the property. So I don't know. Do I give the family access to enter the unit, to take stuff out? I don't know what to do.
I don't think I would give access to the relatives because you have no authority to do so unless you get something in writing from your tenant. So I don't know where the tenant is, but I'm sure the family members know, and I'm sure it wouldn't be that difficult to get a signature on a piece of paper authorizing one of the family members to go in. But right now, this is not, quote, considered abandonment, so I certainly wouldn't change the locks. I would just wait until July 2nd, when rent isn't paid, then I would serve a 3-day notice and commence an eviction. It's all that you can do. Now, you might want to tell the family members, hey, if you can get a signature, not only saying that we're authorized to go in, but that we're turning the unit back. If you get a signature by the alleged deported tenant, then you would be free to change the locks.
And then I would go ahead and do the same thing that you talked about earlier when it came to if their belongings are less than $700, I could just go ahead and take it out. But if it's more, than throw it in the auction.
Yes.
Got it. Thank you.
Thank you. We're going to move on to somebody who went to my alma mater, and that is Aram K. And it says here at CSUN, and when did I graduate CSUN? I think it was 1972. I graduated CSUN and went straight to law school. So how are you, Aram?
I'm doing great. Thank you for taking my call. A little background. So I own a condo on White Oak. You know which one I'm talking about.
Oh, I do.
That your favorite, the complex. The tenant's been with me, and it's an RSO. Tenant's been with me for 10 years. As I said previously, things are going on in that HOA. So I offered the unit to the lady, and she was interested in buying it, and I dropped the price tremendously. We went through escrow, and it got to a point where her lender said, "Uh-oh, there's lawsuits. I'm not gonna, offer a loan." So that got
So
canceled.
there's pending lawsuits, correct?
Yes, numerous, and there's more and more every other week, and it's craziness.
Yeah, it's a bad homeowners association which has created these problems. I know exactly where this property is, and I've literally done, I think, about 99 evictions over my career in that building. But it's really tough. I mean, if there was only one lawsuit, then you might want to put into the escrow that you will be responsible, and maybe you could get the lender to accept it. I know that the house that I am sitting in now, when I bought this house back in 1999, there was a lawsuit against the homeowners association. And the lenders said as long as the seller guarantees that they are responsible, then they let the loan go. And in fact, they did. And then he had to come up with another $25,000. So, but I'm still here 26 years later.
Right. So the question is this: my agent says there are investors out there who will come in and give cash and close a deal in 15 days. Am I allowed to sell a property that's under RSO in City of LA with a tenant in there and just walk away from the whole thing? Or
Oh, absolutely. I mean, people are allowed to sell their buildings. What if you had a 100-unit building? Are you allowed to sell that with 100 tenants in possession? So whether it's one tenant or 100 tenants, of course. And you see these commercials, we'll buy your home, we'll have it sold. So I don't know if that's your only way out of this malaise, because you could get hit as, the homeowners association is going to get hit. And then who's the homeowners association? You. So you and everybody else. So yeah, if you can figure out a way to get out of that building, it's so unfortunate that people put their life savings into this, and that's where they are now. By the way, are you a professor at CSUN?
yes, sir, I teach mechanical engineering.
Oh my
Been
God,
there
you're a
for
smart guy,
29 years.
not like us lawyers.
Oh, I don't know. I wish I knew more about law. And then am I allowed to, if I find a buyer and they want to go inspect a unit, is it just giving them a 24-hour notice and say, we're coming in to do inspection? And
Absolutely. That's one of the grounds for allowing access to a unit. And again, that form's on my website, and that's one of the items you can just check off.
if they refuse access on the day,
Well, then that's good. We can do an eviction at that point.
okay, all right, cool. Thank you, sir. Appreciate you and appreciate your show. I hope you continue this for a long time.
Oh, I'm planning on too. I have a vacation planned, but as I did last year, I'm going to try to do this uh, from the boat. From the
Oh,
boat.
boy.
Yeah, we're
Okay.
on this boat, and I planned it perfectly. So even it's going to like Spain and some other places. I don't even know where we're going, but at least I planned it that I'm sitting in the front of the boat. So when I'm doing the oars and rowing back and forth, I know there's not as much effort than if you're in the back of the boat. So anyway, thank you very much. We are moving on to Nancy P. How are you?
Hi, can you hear me?
I
Daniel?
can. Look at
Yeah,
you, lovely girl.
yeah, I'm sorry. I'm sick, but I need to ask you a question. I'm sorry about that. I have a tenant upstairs that want to move downstairs, and she used an Assembly AB 1620 California Regulation 3301 identical unit that he can move from upstairs to downstairs.
They can if they claim that they have a disability. Does she have a disability?
Yes, she have the disability. She already moved down to the downstairs unit. But the thing is, the downstairs unit have patio, but the upstairs unit have no patio, which is considered the downstairs have storage that she store her table, everything that she can store. And she signed the lease also addendum and also the storage lease that she will lease that separately, and then I incorporate to her rent, and I register it with the rent control board. And after 1 year, right now it's December, I mean it's June, July 20th, it will be a 1 year lease. And she say, I no longer want your storage.
Okay, well, I would have
increase
to,
my
we're getting a
rent.
little far, we're getting a little far afield with this question. I would have to actually review the lease to see exactly how it was written to be able to answer the question dealing with that patio slash storage and see what we could do or not do with that. With regard to the law, you do have to allow if there's a similar unit on a lower floor, if a tenant under the new rules requests that they have that because they have a disability, then unfortunately under the new rules, you have to allow for that. So I'm going to ask that, give my office a call, and maybe we could take a look at that lease. But anyway, thank you very much. Austin, how are you?
Good afternoon, Dennis. Thank you for another week of Landlord Tenant Talk Radio. Can you hear me okay?
Perfectly.
Oh, good. Okay. So my question deals with the 24-hour access rule. I'm using an AOA lease, and it's got all the good legal language in there. But the situation is a tenant gave me her 30-day notice to vacate. She is there's minor children in the unit. She's the parent. And she said that she is not willing to accommodate a open house on the weekends because it takes too long. And I was in the unit for too long doing a repair one time and she got in trouble at work, blah, blah, blah. So my question is, she said she was only available Fridays, and that's pretty restrictive. So what I want to do is serve a 24-hour notice and enter the unit to do showings. But my concern is that she may come back and say, excuse me, you endangered my children. I'm going to sue you for child endangerment, and I'm going to get a restraining order or something crazy like that. So what is your suggestion when you want to do showings to a prospective tenant and there are minor children present and the parent is putting up a fuss?
Well, how is that endangering children by bringing somebody in to take a quick look at an apartment? It doesn't make any sense. So these threats are baseless, and you have the right to show the unit to a prospective tenant by serving a 24-hour notice. I would do it during normal business hours, 9 to 5, Monday through Friday, and unless the tenant wants to allow a different showing. But again, it has to be, you have people who you're trying to lease the premises to, and you obviously want to make sure that it's leased in the shortest amount of time. So I can see your dilemma. However, the other side of the coin is, how is the place really going to look when the kids' toys all over the place? So sometimes it's just better to let the tenant leave and then get the place all cleaned up and then show it. But again, I understand you're concerned about trying to get it rented in the shortest amount of time.
Is it worth going as, like, if she really puts up a, okay, so that's good. I guess that's the law. So there is really no case for a restraining order or something. So then if she really wants to put up a fuss, is it worth telling her, well, if it's that much of an issue to you, I can arrange for the police to be present to keep the peace, and or a child protective social worker to be present, or is that not required?
I mean, I think it's getting far afield, and you're going to have, first of all, it's going to be impossible to get those people there. And secondly, unless you're doing it all in one swoop, which is not normally the case, you get a phone call, hey, I want to see the unit. You show it to them, you get another phone call. So I don't think that's going to be practical, nor do I think you need to do that. So tell them, look, I don't want to lose money. And if you don't allow me in, then to the extent that it took me longer to rent it, technically you're liable because you didn't allow me access when you should have. Anyway, thank you very much. We are moving on to, says here just initials, LKJLC. I'm going to ask you to unmute yourself.
Hi, Dennis. I've got a question about this 24-hour notice as well. Earlier, about a week ago, I had my assistant serve a 24-hour notice on a tenant intending to enter the unit yesterday, which was Friday, June 27th. Unfortunately, on the 24-hour notice, it said Friday, June 26th. And obviously, I didn't realize that was an error there. So yesterday, when I entered the unit, the tenant had cameras there and he was waiting for me. And he basically claimed that I trespassed into the unit. And I'm wondering, have I violated any of these, any law or any provisions of the 24-hour notice? Because it said Friday, June 26th, but obviously June 26th was a Thursday, and I did not go there on Thursday. I went there yesterday, which was Friday, June 27th, although the notice said Friday, June 26th.
I understand the issue. Your tenant is insane. It's just insane. So there was a typo on it. And if the tenant was the tenant waiting for you there on Thursday, the day before? So tell your tenant he's insane, and you don't deal with absurdities such as this. And did you do the work that you needed to do and why you went in on Friday?
He didn't let me in. He said that I didn't have a proper notice. He didn't let me
Okay, so
in.
then how were you trespassing if he didn't let you in?
because I opened the door and I
Uh,
walked in and he kicked me out.
Okay, so then tell him he's insane, and tell him that you'll remember this attitude that the tenant have in any future situations that you have with them, and serve another 24-hour notice and go on in. But your tenant is insane. Anyway, thank you very much. We're moving on to Zena. How are you?
I'm fine. How are you, Dennis?
I am fine, thank you.
Awesome. Well, my question is about security deposit. I have a unit, a home, a single family residence in the city of Pomona, California. And the tenant is violating the contract, the agreement, rental agreement, by having someone there. They're trying to get them there legally, but I just don't think it's best at this time. So my question is, if I have to go through with an eviction because of just cause, how does the security deposit work? Do I have to refund all the security deposit if they keep the unit spick and span, or it's the
Well, I
same
mean, as I
procedure?
stated, from a security deposit, you are allowed to deduct for any unusual wear and tear, reasonable
Okay.
cleaning, and of course, any rent owed. I don't know how that relates to an eviction. Once the eviction is over, you are allowed, because you're obviously not going to be taking rent during the eviction process. So that security deposit will clearly be eaten up by rent. And again, you also are allowed to deduct for unusual wear and tear.
Okay.
Cleaning.
Thank you. That was it. Thank you.
I'm going to go a little out of order here because I see somebody I want to talk to, and that is Ewan. How are you? It's your turn.
Hi, Dennis. Can you hear me okay?
Yes, I think we talked today, did we not?
We spoke on Friday, yes, and you kindly invited me along, and I'm here, and it's nice to see you, and thank you for yesterday, and thank you for today.
And where are you, sir?
I'm in Seattle at the moment,
That's right. I was trying to remember the story.
so I thought I'd come on, introduce myself, because I'll be tuning into these going forward. This is great, by the way. I have a real quick question. It's just following on from what some of the others were asking. What is the proper, or what are the acceptable methods of serving notice, presenting documents for signature with tenants in possession? What's the recommended? Is it email? Is it by hand? Is it certified? What do you have
Well,
to
it,
do?
it all depends what notice you're serving. For example, if it's a notice to pay rent or quit, or some notice that's going to terminate the tenancy, then you either have to hand it to the tenant or post one and mail one. If it's a straight just notice to quit, then that can be mailed by certified mail under California law. If we're talking about, for example, a notice to enter the dwelling, that should just be posted on the tenant's door. Otherwise, you have to do it at least 7 days in advance with regard to posting notices on the door. And of course, if it's a rent increase notice, then it's perfectly permissible to either hand it to the tenant or mail it. But if you mail it, then you have to allow an additional 5 days for mailing. So a 30-day notice is really a 35-day notice, and a 90-day notice is a 95-day notice.
Got it. Thank you very much. That's clear. Thank you.
And thank you. Let's see here. Moving along to, it says here, iPhone. Is there an iPhone there? Yes.
Yeah, how are you?
I hear you now, sir.
Oh, yes. Hi, how are you doing today?
Good.
Yes, Dennis, can you hear me? Oh, yes, I had a question about that 30-day notice, that 3 day to pay and 30-day to quit. I can't find anything online about that. Like, because I
Well,
have actually many tenants in
I
the
can
building.
certainly explain it. Under the laws
Okay.
dealing with federal laws, if you have one tenant in your building that is on Section 8, or if your mortgage on your building is based on a federal loan, like Fannie Mae or Freddie Mac, then when you serve a notice to pay rent or quit, it's a special hybrid form, which is a 3-day notice to pay or a 30-day notice to quit. If you don't have any, if your loan is based with
Mm-hmm.
a conventional lender or no loan, or you do not have any Section 8 tenants in your building, then you're free to serve a standard 3-day notice to pay rent or quit.
Is there in like statute that I can read, or I like looking at laws?
It's under
You
it's
know,
under the
I like
federal
looking
law.
at different types of laws.
It's a
Is it?
federal law dealing with Section
Oh,
8.
okay.
It was instituted during the COVID period, but and they forgot to take it out. So we're suffering under that silly law. Anyway, thank
Okay,
you
and
very
the second
much.
question.
Oh, is there? Oops. I'll unmute. Try it again to unmute yourself for the second question. Can you hit your unmute button?
Yes, I'm sorry about that.
Go ahead.
Okay, so yeah, I spoke with you last week about the issue when I served a 3-day notice on the tenant, and I didn't have my agreement that I made with the tenant for the back rent. So the agreement that I made with the tenant for the back rent was to start paying the back rent on the 1st of July. But any rent, but then the regular rent starting on June 1st. Of course, the tenant did not pay the rent on June 1st. So I served a 3-day notice, but I included all the rent that was due. Should I have not done that because the back rent didn't supposed to be started being paid until July 1st? So should I just
Well,
reserve a new notice?
I would reserve a new notice
Or
unless your agreement specifically said that if you miss any payment, then this deal is off and you owe me all the rent. But if it didn't say that, then technically that rent from months ago was not due until July 1st. Anyway,
yeah,
thank
it
you
doesn't
very
say that.
much.
Thank you so much.
My pleasure. And guess what, everybody? We made it through another hour of Zoom Landlord Tenant Talk Radio. I do appreciate everybody coming out. Once again, if you are watching this on YouTube, please hit that like button and subscribe to the channel. And also leave me some comments on questions or topics for future shows. I want everybody to have a great weekend. And with that, I'm going to say goodbye. Have a good day.